It's an important occasion for corporate professionals today as we are celebrating our third anniversary of the webinars organized by us every Friday. And fortunately, it's also our 125th webinar. No better day to celebrate 125th webinar. And we started our journey in year 2022, the unfortunate year of pandemic. But it's been a journey fulfilled with idea, knowledge sharing, and support from all these stakeholders during last 3 years. As we celebrate our third anniversary today, I would like, first of all, before going to introduce the panel and to start with the webinar, to take this occasion to offer our gratitude to all the legislators, government officials, officials from regulators, ministries, SEBI, IBPI, industry leaders, subject specifics, and to all the participants who have participated in such a huge number during the last 3 years. It's your continued patronage and motivation which has continuously pushed us to organize the webinar every Friday during the last 3 years. So today, before every year when we are celebrating our anniversary, we've always used this platform, apart from sharing knowledge, to discuss a topic of national interest. And today, again, on the occasion of third anniversary of our webinars, we have chosen a very relevant and important topic to discuss, that how to reduce the burden of court cases in India. And to discuss this topic, we have a great panelist with us, directly from the four corners of the law, the courts of India, and from regulators who are dealing with this subject on a very regular matter. And they are the best persons to speak on this topic and to share their views, how we can work towards achieving the objective of reducing the pending court cases in our various courts across the country. So to begin with, I'll first of all introduce the esteemed panelists for today's webinar, and then I'll give you a brief outline as to what we've achieved during the course of last 3 years. And then I'll ask Mr. Pawan Vijay to take the webinar forward with all the panelists available. So to start with, we have Honorable Mr. Justice Alok Mathur. Sir is Judge of Allahabad High Court. He's worked as a standing counsel for Chancellor of Universities of UP, His Excellency the Governor Union of India, Food Corporation of India. He has practiced in criminal, company law and service matters for a period of 28 years. I extend my hearty welcome to Mr. Justice Alok Mathur. Then we have Honorable Mr. Justice Sandeep Kumar. Sir is currently acting as Judge of Patna High Court, and he did a lot of retained counsel for large number of corporates, including biggest infrastructure companies of the country, and was also the advocate of Government of Bihar and Union of India. I extend my hearty welcome to Justice Sandeep Kumar. Then we have Justice S.N. Digraji, former Delhi High Court judge. He practiced company law matters, criminal matters, labor matters, worked in matrimonial courts, designated Tara courts, special 1984 right courts, appellate courts of MCD. I welcome Justice Jhingra. Then we have Ms. Muktulika Vijayvargiya, ex-full-time member of IBBI and ex-additional secretary, Ministry of Law and Justice, having more than 42 years of experience in the field of law in various positions. She was associated with drafting of more than 100 legislative proposals on various subjects administered by different ministries. I welcome Ms. Madhulita. Then we have Mr. Siddharth Luthra. He's a senior advocate at Supreme Court of India. In 2012, he was appointed as an additional Solicitor General of India, the Supreme Court, and represented the Union and various state governments in matters relating to fundamental rights, electoral reforms, etc. I welcome Mr. Luthra to the webinar. Then we have Mr. Mohit Mathur, a senior advocate and president of Delhi High Court Bar Association. He has received presidential reference to address in the interstate Kaveri water dispute, and have also fought many other prominent cases in the country. I welcome Mr. Mohit Mathur. Then we have Mr. P. Nagesh, again a senior advocate with over 26 years of experience in corporate law, advisory and litigation. He's a research-oriented person and has represented wide-ranging and complicated nature of corporate cases before the Honorable Supreme Court of India, Honorable Delhi High Court, and Honorable NCLT. I welcome Mr. P. Nagesh. Then we have Mr. Ravi Prakash, associate partner at Corporate Professionals, heads the securities law and corporate litigation team. I welcome Mr. Ravi Prakash. And then we have Mr. Pawan Kumar Vijay, founder at Corporate Professionals, and the man behind the success of all the 3 years of webinars. I still remember at times on some Fridays, we rush to find a topic or we try to find a way to avoid holding a webinar on Friday. But his consistent persistence is the result. Today, we are celebrating 3 years of our webinar and hope we'll continue to celebrate this further. So today's topic: how to reduce the burden of court cases in India. The burden of court cases in India is quite high. India has one of the largest and most complex legal system in India, and as a result, the number of pending cases in Indian judicial courts is extremely high. With the esteemed panel available today, we'll discuss on matters on how we can work towards improving this rate and reducing the number of cases pending. Before I hand over the baton to Pawan sir to take this forward, I'll give you a brief overview of what we have achieved during a period of last 3 years. Since this is our 125th webinar, so last 124th webinar. So corporate professionals is a leading group of dedicated research-oriented skilled professionals rendering techno-legal and financial consultancy services. Based out of our knowledge and experiences, what we share during the course of the webinar. During the COVID-19 COVID-19 pandemic, we started the activity as a knowledge warrior and thought when we all are sitting at home, working from home, why we should not use this opportunity to start a new revolution of sharing knowledge in India. And as a result, we have continuously on every Friday shared knowledge. We were heartened by the massive response. So in last 3 years, we have organized 124 webinars on subject matters of corporate law, securities law, IBBI, decriminalization, lot of things. Regulatory updates from this year onward. We have started every Friday, first Friday of the month, we share regulatory updates of the last month on taxation, labor laws, POSH, insolvency, valuation. So you can see over a large variety of topics we have held webinar. So the first webinar was on 28 April 2020. I was fortunate to part of that webinar, and I am fortunate to part of the webinar as we celebrate the 3rd anniversary today. And last webinar where we completed 124th webinar was on buyback. Shivam. So more than 90,000 people have associated with us during the last course of 3 years. These are unique numbers over a course of 124 webinars. We have received more than 5,000 queries and we're able to resolve them either on the webinar or by way of emails. Some of the top webinars were demystifying corporate law. That's a Q&A series we started last year. Then on demonetization, amendments. We received large number of queries and 252 queries in a single webinar, and we were able to resolve all of them during the course of the webinar. 181 speakers across 124 webinars. It's all because of the prominent speakers that participated, shared their experience and knowledge is what makes the webinar successful. We have eminent members of parliament who joined us during the course of webinar. Government officers from IAS, IPS, IRS, then regulators from Ministry of, then MCA, being supportive from MCA always, IBBI, SEBI again, then Stock Exchange, GIFT City, ex-regulators, industry leaders. They have been kind enough to grace our occasion. Senior officials from SEBI, BSC, NSC. Some of the clients, we thank them for sparing their time on the webinars. How we've impacted the impact that our webinars have created over a course of time. So education dispensation, that is always the first objective of all our webinars. Clearing the doubt of participants on various issues faced by professionals and industry. Connecting regulators and audience, because one can raise their queries to the regulators that join our webinars. Discussion on various consultation papers which have enabled us to share our views on the consultation paper with the regulator. Sharing knowledge repositories in form of FAQs, videos. Promoting good corporate governance, compliance culture among the corporates, professionals. This was the impact. We also discuss how webinars impacted. So we have our suggestions helped SEBI in coming out with settlement scheme, new listing regulations, changes in the PIT regulations, reforms in securities law, ESOP. After the queries received by us during the course of our insider trading webinar, SEBI come out with FAQs on PIT regulations. Our suggestions on Ministry on Corporate Law, CSR, MCA more than 23, company law reforms. We also came out of a book on Handbook of Mergers and Amalgamation of Government Companies, which is a result of our one of webinar. We gave suggestions to IBBI on pre-packaged insolvency resolution process. So sharing, apart from the webinar, we do offer a lot of services in various areas. And all our webinars are mostly driven out of the practical experience that we gain from the work that we do. So this helped us not only in better understanding of these service areas and also able to deliver to the clients and to the stakeholders at large through webinars and a lot of other initiatives that we take. Some of our other knowledge initiatives are CP shorts that we send across to many people across the country. We send over 1 million mails every month in terms of to share our knowledge. CB Connect is a fortnightly feature. So CP shorts, CP Newswire, there's a newswire we send. Then CP Connect, first day of every month. So journey will continue. We hope to your patronage for times to come. And now I'll ask Mr. Vijay to take this matter forward.
Thank you very much, Ankit, for show us this. And now, friends, I will start this topic we have selected because we have decided whenever we are having a program, if it's 150, 175, 200, we'll select the topic of nation's interest. So that's why we are discussing today burden of court cases in India and what are the impacts. So friends, I'm just giving a brief outline this because problem caused by this pendency that we know justice is justice denied, court are overburdened, litigation costs are increasing, and judiciary lose credibility because of this pendency and rule of law is disturbed. This is the pendency of, if you remember, Justice N.V. Ramanna, former Chief Justice, has said that India losing 1.5% of GDP due to delay. And Justice A.K. Goyal in 2018 has said that because of this delay, this is affecting country's economy. And that's why he suggested that this is a need of our justice, judiciary, bar and members, and the government work together and come out with some solution. Then the pendency of court case, if you see, it's a huge 70,000 cases pending in Supreme Court. That is as per 23 data. It has reduced. That's a good sign. Out of 70,000 to 68,000, and then continuously every year it is going. And the High Court, the 56 lakh cases pending, which has increased to 59 lakh. That is as per 23 data. If you see out of the High Court, 72% pending cases in the High Court are civil in nature. That is distributed to all. And then subordinate courts, 4 crore cases, which has increased to 4.34 crore as compared to 21 to 23. And interesting is the subordinate courts, 73% pending cases are criminal in nature. In High Court, this is the reverse. It is a civil, and lower court is a criminal. Then in fast track court, they came out with fast track court because of the justice can be given faster. But today we have 9.2 lakh cases are pending here. NCLT came out with this part that tribunal will reduce, but today, 2023, 21,000 cases are pending in NCLT, which has come out to reduce this. If you see the age-wise, 0 to 1 year, 32%, 1 to 5 year, 45%, and 5 to 10, 15%, and 10 to 30, 8%. This is subordinate court. And in High Court, 20, 39, and 20, and 20%. So you can understand 10 years to 30 years, 20% cases are pending in High Court. So this is a huge number. Vacancy in judiciary is also there. And you can see this, some sanction strength versus actual strength. High Court, 30% vacancies are there as per Indian Justice report. Next. Then you see the vacancy in judiciary subordinate, 23% posts are vacant as compared to the sanction. Then in National Company Law Board, they have sanctioned 63, but there are 25 members out of this sanction limit. So this is a huge number which is pending, and this is one of the reason of delay. And if you see the number of under trials in prison, more than twice the number of convicts. So you can understand this is the percentage across the country, which is very high and which is serious, and it is giving a life of liberty. Now, kind of efficiency, inefficiency we can see. Then there's a reason that inefficiency is because of so many reasons. Uh, Registry side inefficiency, service notice inefficiency, counsel short time, counsel was absent, delay condoned, inefficient time to hear cases, judges absent. So these are the things. And out of this, 80% because of advocate, 20% because of judge. Now this inefficiency across the board, that is there. Now I have some suggestions. This is I have given name of test, technology, efficiency, standardization, and training. So if we see if we can do something on technology part, then we can reduce lots of. So first is the data collection and its conversion into information because of the transparency. Websites are not effective. They should be more effective. Data should be analyzed so transparent MIS to judge the all concerned. That is there. Then come to the efficiency side, improvement in case proceedings, address counsel side inefficiency, court side inefficiency because infrastructure is required, and then prioritize demand side solution. Frivolous complaints should be reduced, encourage ADR solution. And the most revealing fact is that government cutting on litigation, that is very important. Today, currently, government is single biggest litigator, constituting 50%. That should be reduced drastically. And if it is, it can be done, the things can change drastically. Next is efficiency improvement in case putting. The ADR mechanism should be utilized properly. It should not be become second leg of litigation. Use of technology in ADR system, that is there. And another suggestion which I have which I'm suggesting, that we have a mediation center. Now, if in the mediation center, if we can start opinion-based evaluation system at pre-mitigation stage, where both the party can file their things to natural evaluation and non-adversarial and lean model. And here they can submit their facts tried by both the party and make the issues that what are their point and what are others' point, and then the sum of the judicial member can provide the opinion, and that opinion, if you are accepting, then you can withdraw case. If you're not accepting, then you can fight the case. So this can reduce lots of cases in the court. Then come to the standardization. I was a chairman of Secretarial Standard Board in Company Secretary Institute, and we have done the standardization of all laws of connecting to the company law, all points of all various sections of company law. So standardization is always giving result. So if we can follow this, so the procedure of filing, contesting should be standardized across the board, all the court, across the all cities and across all subordinate to law top courts. Use of infographics, which can give it faster result in place of writing and talking about so many things. And software should intake people filing the case and translating the court desirable manner. Because what is happening, you are giving your opinion, everybody is giving in a different way, that can be standardized in the procedure. That is one part. Then adjournment to be reduced, structure, enhanced timelines to making pleading and submission. If it can be given, so many things can change. Next is, if you go to this, adjournment process will reduce and timeline will be followed. Next. And then come to the T part, training judicial system, court staff to be given trained, support staff, ecosystem of judges to be institutionalized, because they should have more people, because judges are burdened so many things. So they can, it is an ad hoc system. You have a complete team of judges where they have a research team and everybody is there. Regular training for the advocates and their staff. Authority should be appraised the decision of higher court, revamp the legal education, and that is there. Sometimes what is happening, High Supreme Court is passing some order, but lower court is not following, they are taking own decision. That should be strictly monitored. Then come to the next. Then come to the next point, that the excess of next point. So the next point is that how reduced dependency will affect the situation. That is important. If we can follow this, then access to justice will be improved, law enforcement will be strengthened, better protection of fundamental rights, upholding rule of law, and safeguarding of democracy. If we can do this, I hope that this can change this. And by some suggestion, let's hear from the people, those who are in and out, they are facing things. So I will request now Justice Alok Mathur to give his view on this topic, how we can take advantage and what the courts are doing and what you as a judge is doing. Over to you.
First of all, a very good evening to you all. Brother Sandeep Kumar, Brother Dhingra, learned senior advocates on the panel, all the eminent panelists. Firstly, I'd like to congratulate the corporate professionals for conducting the webinars for the last 3 years very diligently. So I've heard done a very great job. Well, coming to the topic for this evening is regarding the burden on cases of the courts. So firstly, don't take this burden as courts as something negative. In such a large country where you've got a legislation for probably everything you can dream of. And every legislation either creates rights or defines rights or limits the rights. Definitely it has a judicial impact. Very simple laws have certainly had a great impact on filing of cases. 138, Negotiable Instruments Act. Certainly you've got these magisterial courts filled up by litigation for bouncing of checks. I don't think they realized that a dozen of our magistrates in every district are flooded with cases. So, and legislature is passing laws after laws, but the judiciary is stagnant where it was. The appointment of judges, as you've already said, is again at the same place. So, but the point is, we have to tackle this burden. We can't wish it away. And in my words, every case filed is a vote of confidence in favor of the judiciary. So the point is, how do we tackle this? Either we simplify the procedures, we can expedite the hearings, and definitely, as you just said, appointment of judges. There are various things. This is one topic which can actually we can discuss for days rather than hours. What I was asked by my friend was as to how is the High Courts dealing with this matter? What are we doing? So I will, apart from this, before I come there, I'll just tell you that yes, we have to reduce the burdens. Broadly, we have created a lot of tribunals for special sort of litigations. We have the MP and MLA courts in state of UP where all their matters, criminal matters, are taken by special courts. We have special courts for customs. We have commercial courts now, which we have established, family courts, special courts for TADA, motor accident claims tribunal, family courts. This goes on and on. But this, it hasn't really reduced the burden. We have those special courts, undoubtedly. Even they are flooded over a period of time. In family courts, if one goes, I mean, just by seeing the numbers and the crowds, you can imagine what the pendency is. The other thing is, we did create a lot of tribunals, a lot of specialized, like Central Administrative Tribunal with the Armed Forces, but somehow it seems they did not work too well. And this observation has also come by the Supreme Court in the case of Roger Matthews, where the Supreme Court slowly and steadily is now reverting back to the High Courts. So whatever jurisdiction has been taken away, they are slowly and steadily coming back to us. Now, as a High Court judge and being in the High Court, we have a constitutional duty also under Article 227 for supervising all the low subordinate courts. In this regard, we do have a responsibility. We have the primary responsibility to see that the burden is somehow reduced. To that extent, I can inform you that we have committees of judges, and we are constantly monitoring particular areas of litigation, what may be probably of special interest to you, that all the matters under Section 34 of the Arbitration Act. We are requesting our district judges to see that they are disposed of at the earliest. We are monitoring them on a very regular time period. We are in conversation and we hold meetings with our district judges. And we slowly try and tell them, please, at the earliest, these are the matters of priority. Try and list them frequently. And in your daily list, please see that a few matters are there and they are disposed of at the earliest. Definitely, commercial matters are something which we all want that they should not be pending for long. As Mr. Pavan Vijay rightly said that he talked about pre-litigation mediation. So I'm sure you're aware that in the Commercial Courts Act, there is a provision under Section 21 for pre-litigation mediation. And before even a case is instituted in the court, party is mandated to go for mediation. And it is only on the failure report that you can institute a matter. So, but it is at this very infant stage. We have yet to see the fruits of pre-litigation mediation. But I'm sure slowly when people are made aware of the benefits of mediation, they'll come to know. As again, you've said, all these things are known to all of us is the ADRs. Initially, we started with the alternate dispute redressal mechanism by stating that this is the burden of the courts and it should be deburdened and the load should be taken by these other mechanisms like arbitration and mediation, lok adalats and judicial settlement. But somehow they have been very effective. And one of the most effective procedures we have devised is the mediation. Now, mediation is something which, as far as my friends who are in the fields of finance and industry would realize, that it is a very speedy mechanism for resolution of disputes. And as I would say, it's a different manner where it is an adjudicatory, it's a participation. Such a participation is not there in any other form of resolution of disputes. Once a party takes a matter to the court or to the arbitration, after arguing the matter, it's up to the courts to give a verdict either way. If you like it, well and good. If you don't, go up in appeal and revision. And the point is the litigation continues. Now, the benefit of the mediation is A, that you are in control of the outcome of the result. So wherever there's a fiduciary relationship, that is especially there in the fields of business, where the principal and agent, where a consumer and the other person, these are areas where mediation should be promoted. And in Uttar Pradesh, we are promoting mediation. Every district, we have mediation cells. The MCPC is training mediators in the High Court level as well as the district court level. We did not have a very strong start in 2007, where I myself was trained as a mediator initially. Until 2017-18, I was myself conducting mediations. And we have done mediation in commercial matters also. It is not that only in family matters, mediation has been successful. I'm happy to tell you that in a number of big commercial matters, the mediation has been successful. Yes, you require a dedicated set of mediators with the proper training. They can definitely deliver. So these are certain areas where people are not aware of it, first of all. I don't know how many people know that there is a compulsory or mandatory mediation in the Commercial Courts Act. So propagation of this matter to tell the people what exactly is mediation. People are not aware. I myself usually go and tell our brother judges in the district judiciary, in the Judicial Training Institute here, because unless the presiding officer himself is aware of the process, it's very difficult for him to refer a matter to mediation. So you have to be convinced yourself. So friends, these are certain manners which as the High Court, as an institution, it is our responsibility and we are discharging that to a great extent. We are administrative judges of various districts. We constantly monitor the work being done by the districts. But the volume of litigation is something where only there's a limit beyond which you can't do. You can't. Can you believe you got 150 cases before me to try every day? As a human, I don't know if you just sit back and realize as to how is it humanly possible to deal with this such a number of matters. Still, out of, I would not like to tell the number because I don't think that's, but there's a huge number we dispose of every day, and probably all of our judicial officers are doing their bit. But the institution is again, people in other parts of the world would not know our institution. I can just tell you that in one of our jurisdictions, the filing every day is 350 cases a day. Can you tell me any other court which has that? But we are grappling with it, and we are trying our best to see that we don't add to the pendency, and it's a fighting operation every day. So friends, this was the little input which I could give you. I can assure you that we are on the job. We are hands-on the job. If more appointments are made, all the procedures are simplified, we can grapple. It's nothing which is extraordinary, but it will require a dedication for all of us. And certainly, training is something which Pawan Vijay mentioned, and I really believe that the more you're skilled, the more better equipment you have to deal with the problem, definitely we'll be more successful. So these are a few of my thoughts I thought I'll share with you. Thank you so much.
Thank you very much, Alokji. You have rightly pointed out and the problems of judges because I was with Mr. Justice Dhingra in one tribunal, and Justice Dhingra gave me one. He told me, write this order. You should write. So I can realize telling and seeing is different. When you are writing, then you are thinking, if I'm writing this, it will be precedent. And if I'm writing, should not be wrong. If I'm writing something, it should not affect the wrongful things. So I can understand this point, and you are right that it is not possible. That's why there is a need that we should use technology. We should use the different things in work. So thank you very much, Alokji, for you. You now come to our another learned Justice Sandeep Kumar. We all are from the product of Compass Law Center. So I request Sandeep, Justice Sandeep, please tell your views.
Honorable Justice Alok Mathur, Honorable Justice S.N. Dhingra, Sri Siddharth Luthra, Senior Advocate, Mohit Mathur, Senior Advocate, Sri Pawan Kumar Vijay, Ms. Vijay Varghia, Sri P. Nagesh, Senior Advocate, Sri Ravi Prakash, and other friends who have joined this webinar. Before I begin, I can only say that Honorable Justice Alok Mathur, myself, and Pawan Kumar Vijay are batchmates from Campus Law Center. So when Mr. Pawan Kumar Vijay commanded that I must say something in this webinar, I had to, initially I was not ready to participate because of the workload in my court, as well as because we have to work after court hours also. We have been working. So, but on the request of a good friend, dear friend, Pawan Kumar Vijay, we have joined, both Alok and myself have joined. The issue of backlog of cases, how to ease the burden of the court, is an interesting issue. We have been participating in seminars. We have been hearing people talking about it since long. But the problem about easing the burden of the courts cannot be sorted out just by judges. It has to be, the participation should be of the litigant. It should be from the side of the advocates and everyone. This issue affects the very fabric of the society. Our constitution framers have dreamt of having a true democratic nation, and we, being a part of the institution of justice, have the opportunity to carry forward this dream by creating a nation ruled not at the whims of dictators but by adhering to the rule of law. The preamble to the Constitution emphasizes the importance of ensuring social, economic, and political justice for all citizens. Article 14 envisages the fundamental right to equality before the law and equal protection under the law. And also, Article 21 guarantees that no person shall be deprived of their life or personal liberty except in accordance with the procedure established by law, which leads us to the way that access to fair, quick, and speedy justice is the fundamental right of the citizen, and the same was upheld by the Supreme Court in the celebrated case of Hussaini Ara Khatun versus Home Secretary, Government of the State of Bihar. However, the staggering number of pending cases in our courts has been a cause of concern for decades, which has adversely affected the timely delivery of justice. In our country, with a population of over 1.4 billion people, the sheer number of disputes that arise every day is enormous. While we have a robust legal system in place, the long drawn-out legal proceedings, adjournments, and the appeals have resulted in an alarming backlog of cases. According to the National Judicial Data Grid, as of February 2023, over 59 lakh cases are pending in the high courts across the country. This backlog not only undermines the faith of the citizens in the judiciary, but also poses a significant challenge to the efficient functioning of our democracy. The huge pendency of cases is a multifaceted problem, and to reduce the burden of the cases, the solution has to be comprehensive. Since long, there has been a chronic problem of shortage of judges. According to the recent data, the present number of judge to population ratio, judge per million population, with respect to sanctioned strength of judges is 21.03 as on December 31, 2021. The Law Commission report now of 1987 recommended at least 50 judges per million people of India. However, as of January 23, we have 21 judges per million people, as the government recently informed the Rajya Sabha. Increasing the number of judges will help in disposing of cases faster. It is pertinent that the focus should not only be on increasing the strength of judges, but also on the quality delivery of justice. And to ensure this, it becomes important that our presiding officers should be properly trained and monitored. To ensure competence, proper selection, freedom of action, training, motivation, and experience are required. Some national judicial institutions must be properly structured in order to provide such training. A systematic assessment of the training needs of judicial personnel at various levels is required. Though the training, every state has now come up with a judicial academy, but the pressure on judicial academy of training the judicial officers is much more, and it is not yielding the required result. And we are trying to take the training module forward so that judges are being trained in the recent commercial laws, including the law of arbitration, Commercial Courts Act, etc. The Law Commission of India has highlighted the fact in its 230th report published in 2018 that the government is the biggest litigant in the system. As on April, the legal information management briefing system shows that there are 6,40,408 cases involving the government of pending before the court system. It is possible for the government to have a litigation policy directed towards the reduction of the government litigation and protection of public interest by preventive strategies. So far as Bihar is concerned, the government of Bihar has a litigation policy, but it is not being seriously followed. Other states should also have the litigation policy, and the Union of India, I don't know whether it has a litigation policy. And the covered matter should not be appealed against, but the government officials, they don't take a decision as not to appeal. They, even if it is a covered matter, they go in appeal, and the order of the court attains finality only after the appeals are disposed of by the Supreme Court. It is important that the litigants should be encouraged to take the recourse of alternate dispute resolution methods such as arbitration, mediation, negotiation, lok adalat, and well-structured and channeled plea bargaining mechanism, etc. This will not only save time and money, but also help in reducing the burden on courts. The efforts to encourage the dispute resolution through arbitration is commendable in last few years. The Honorable Prime Minister, in one of his speeches, specifically emphasized the role of importance of arbitration, he said that, and I quote, "Business seek assurance of the prevalence of rule of law in the Indian market. They need to be assured that rules of the game will not change overnight in an arbitrary fashion, and that commercial disputes will be resolved efficiently. A robust legal framework backed by a vibrant arbitration culture is essential." But in the recent past, as you may be aware, the Board of Advance Ruling has been changed. Earlier, the Authority of Advance Ruling has been replaced now by a Board of Advance Ruling. Earlier, the advance ruling mechanism was presided over by a Supreme Court judge, and there was no appeal. Now, this board is headed by Chief Commissioner, Income Tax, and any party can pursue its appeal. So, there is no finality to the advance ruling also under the Income Tax Act. So, this in fact is a step backward instead of taking the step forward with regard to the income tax law. On one hand, where arbitration has been the mainstay of ADR mechanism, the mediation also had the huge potential in achieving amicable settlement of cases, specifically the matrimonial and family disputes. Although matrimonial, mediation and reconciliation are mentioned in various statutes in India, there is no standalone law that addresses mediation as a visible mode of alternative dispute resolution. The Government of India introduced the Mediation Bill 2021 in Parliament in order to have a consolidated law on mediation, and hopefully it is expected to be passed soon. Along with the ADR, the Lok Adalat program should also be done efficiently on a massive scale across the country to settle the disputes. Furthermore, there is no iota of doubt that judiciary, especially the subordinate judiciary, is in greater need of basic infrastructure. Among several reasons, the poor infrastructure is one of the roots of the backlogs. The inadequate funding for infrastructure by the government makes it unable for the courts to run efficiently. And it is obvious that for working of any institution, it is in its full potential, adequate funds is an important ingredient. The condition of lower judiciary in regards to this is highly miserable. it is evident that there are not enough courtrooms to accommodate the required number of judicial officers for adjudication, and consequently the cases are piling up. In addition to it, there is lack of proper sanitation, law libraries, first aid room, crash facilities, and lack of security issues at lower judiciary. The tug of war between the government and judiciary has to end, and they must come together and work amicably to resolve the issue, starting from better infrastructure at grassroots level to the appointment of judges at the top. In the recent past, the government has been trying hard to improve the infrastructure. So far as we have been seeing in our state that new buildings are coming up, they are giving facilities also, but we have to achieve much more. Our judges in the trial court are still taking the depositions by hand. There is still shortage of deposition writers, stenographers, and other menial staff, which affects their performance as judicial officers. Modernization and digitalization of the courts is one of the important factors. It needs to be understood that with the adequate infrastructure, there comes a need of modernization, computerization, and digitalization of the courts. The advancement of technology has given us a golden opportunity to reduce the burden of courts. The e-governance program was started in the late 90s, but accelerated after the enactment of Information Technology Act 2000. And later, e-courts were launched as a part of National e-governance plan. The pandemic amplified the need to strengthen the digital capabilities. The Honorable Finance Minister, while presenting the Union Budget of 2023-24, has announced an outlay of rupees 7,000 crores for launching the phase 3 of the e-court projects in her speech for the efficient administration of justice. Apart from the e-court project, the judiciary should also adopt other new cutting-edge technologies like the use of machine learning and the application of artificial intelligence in the court system for delivery of justice on time. In between the digitalization and the automatization of the courts, one thing should be kept in mind, that all efforts will become in vain if no proper training will be given to the judges, officers, and staffs of the courts. The digitization of records would ensure the easy access to information to the litigants, but again, there is a need of awareness programs to make these litigants well versed with the new technological advancement of the court, so that they can take the advantage of the digitalization program. Therefore, a digital infrastructure could provide services to the litigants just within a click that will bring the efficiency and transparency in the system. The above discussed scenario, however, may take time to achieve its objective, but at instance, certain steps could be taken where bar and bench can work together to curb the pendency issue. First and foremost, things that need to stop is the issue of frequent adjournment. The advocates should prevent themselves from seeking adjournments on unnecessary grounds. Secondly, the alternative dispute redressal forum may be created inside the court, and a panel of lawyers may be appointed who have a long years of practice on arbitrations matter to deal with the cases. Thirdly, there should be recruitment of more number of court staff to support the court management. Fourthly, the cause list should be prepared early, and the same should be communicated to lawyers in advance so that they can get enough time to prepare their cases and avoid unnecessary adjournment. The proper implementation of the projects pertaining to the establishment of fast-track courts and Lok Adalats would favor in reducing the burden of judiciary. There are many procedural formalities that need to be completed before a case can be heard in courts, which takes a lot of time and leads to delay in resolution of cases. So there is need to change such complex procedure into simple and easy process in the best interest of the people who knock on the door of the court. Recently, we have in Patna High Court, in the jurisdiction in which I am sitting and deciding cases, there are 50,000 cases pending. So a judge cannot deal with all those matters over a period of time. So, it is the cooperation of the lawyers required for disposal of such a huge number of cases. And time has come to pass orders for short arguments by learned lawyers. And similarly, judges should also pass short orders. As Honorable Justice, one of the judges of the Supreme Court, Justice Kaul, in a function at Patna had said that the judges should have the skill of précis writing. The orders should be short, crisp, so that time of the litigants is saved and the output of the judges is more. I can safely say that so far as the High Court judges and the judicial officers are concerned, they are working hard to ease the burden of the courts, but it requires the cooperation of
You are unmute, Justice Sandeep. Yeah. So, thank you very much. Thank you, Justice Sandeep Kumar, for your actual ground reality issues related to ground realities and what is connected, and the way you have pointed out the subordinate courts issues related to modernization, digitalization, computerization. No doubt, everybody, government, bar and bench, all should come together and come out with solution. So thank you very much for your valuable suggestion. Now, because we have heard two sitting judges of the High Court, now comes to the turn of advocate side. And this advocate is not a normal advocate. He was the ex-additional Solicitor General of India also. He must have faced and he has realized. So what is his view? Let's listen, Siddharth Luthra.
Good evening. Good afternoon, or rather good evening, if I may say so. Thank you all. Justice Dhingra, Justice Kumar, my friend Nagesh, Pavan, and Mohit seems to be missing, and Ms. Vijay Varghya. Thank you all for, Justice Mathur, thank you all for giving me the opportunity to speak. We need to, focus on two things. The first problem is that, are we doing enough? That's a question we need to ask ourselves. Are we really doing enough? And speaking for myself, it's the lawyers and the judges are part of the administration of justice. My professor, Professor Bakshi, has recently said that we should not use the word the justice system, because he says it's an administration. If it was a system, we would be a lot more systematic, which we are not. And I think I tend to now increasingly endorse, Pavan, you recall he was our professor, and increasingly endorse his statement. The fact is that the judicial system is the last bulwark against state excesses. And to To quote a senior gentleman who taught me in the early years of my profession, he said, two people go to court. One, those people who have no other access to recourse, and otherwise, the second category of people who want to make sure that you are depriving somebody else of their rights. So these are the two kinds of people who will land up in courts. And the reason the second kind of people land up in courts is because of the problem of pendency. They know that our system is so clogged with numbers that justice delayed is often achieved by litigants. And I'm not just talking unscrupulous litigants, because the biggest litigant in our country is the government. And that's the numbers that the government deals with is absolutely shocking. We must also remember that the legal system, the legal administration, and the legal and lawyers and judges are no longer just part of a noble system. We are actually providing a service to the litigant, government or private, who comes to avail of that service, because that's part of the ethos that is now developed over a period of time. The litigant wants court to deliver justice, and sometimes, very honestly, it becomes a little awkward for a lawyer to explain to a litigant, or even for a judge to say why he or she cannot take up that matter at that point of time, and why the client must get a deferral. Sometimes the sheer numbers. Today I was on a VC in Madras High Court. The Honorable Judge was gracious enough to entertain my request to take the matter at 2:15. But let me tell you, he had 428 cases on his court. The other day in Jodhpur High Court, I was before an honorable judge who has not been able to take up miscellaneous applications, which we had to move on some urgency, because he said, look, I have 200 matters every day. I will first look at liberty matters, and then I will deal with other matters which come up in my board, because there is a large number and that's becoming a problem. So the National Data Grid tells us 4.9 crore pending cases across the judiciary, 1.9 pending for 30 years, 56 lakhs pending for more than 10 years. Shocking numbers, no? 49% and 29% of these are pending for more than 5 years in the high courts and low courts. Frankly, more often than not, lower courts are a lot more expeditious in their dealing, as Justice Dhingra will tell you. He was a very, very expeditious judge, both in the sessions and the high court. And the point is, you find matters getting clogged. I mean, illustratively in Patna, appeals on the criminal side in serious cases sometimes take up to 20 years to be heard. 20 years. On 1st April 2023, 69,000 odd pending cases before the Supreme Court. Almost 50,000 are admission matters, notice, post-notice. 19 odd thousand are final hearing matters. The final hearing matters don't see the light of the day. Constitution benches don't always see the light of the day. It takes long. I'll tell you, I did an analysis on this. Sometimes important matters before constitutional benches, which need to be determined, take as many as 5-7 years. We have the money bill matter, which is just pending in the Supreme Court. Privacy took so long to decide. 9 judges have decided, then it went back to 5. In 2018, the Law Commission notes, as I told you earlier, government is the biggest litigant, and no surprises here. The Finance Ministry is the biggest in government, and follow that with labor, wonderful, and railways. So much for being a society which talks about social justice when our constitution speaks of social justice. In the past 10 years, government has incurred a small amount of 511 crores on legal expenses as the center. But I must tell you, just to pay lawyers, and we're not talking about other expenses, the point is something more, and this is gross. And I haven't been a law officer myself. In my time, this doesn't reflect the true state of affairs, because the bills are paid 4 years later, sometimes. Now about 2 years later, 1 year, 2 years later. So you're really looking at a backlog of things which are pending. So this is just a microcosm of what's done. Judges population ratio, 20 judges per million population. A country which has overtaken China, can we afford to have only 20 judges per million population? The sanction strength of judges in the High Court was 1,114 as on March 23. Working strength, 800 odd, less than 800, so 70% only filled. And a lot of these are actually additional judges. They're not confirmed judges. Keeping in view this situation, you know there is a serious problem on pendency. On the criminal side, prison populations continue to rise. And it is now, the static population at any point is about 5 lakhs odd. But we have to understand that we have about 18 odd lakh people in and out of our prisons every year. Those numbers are not very clear because we don't have the numbers necessarily. Your prisons are, well, 30% of your prisons record an occupancy of 150%. Hotels don't get that kind of occupancy. They only get 70, 80% occupancy. And 50% of our prisons have more than 100% capacity. Imagine if that was a business, they'd be very successful as a hospitality business. So more than half the prisons in 23 states are usually overcrowded. The Supreme Court, of course, comes in and gives in guidelines. In Supreme Court, in the bail matter, Supreme Court has given until. And the point is that these interventions by the Supreme Court or the High Court and guidelines ensures one thing. They're really relevant till a point of time because they are not judicially mandated. There's now talk of bringing in a bail act. And the problem, at least in the exercise of discretion, whether on the civil side, commercial side, or criminal side, is that the consistency is that it is inconsistent. That is the only consistency we can talk about. And that is the problem we suffer with. Now, I don't want to take too much time more because there is a lot. If you were to start me off on a conversation about the state of our criminal justice administration, as I may call it, I will spend a few hours and the other speakers will not get a word in edgeways. As it is, and a lawyer has a captive audience, he doesn't let the audience go. And in a webinar, when questions are not coming, it's easier to go on and on. I think we really need to now relook at a serious revamp of the system. We need to introduce an intermediate court, Court of Appeals. We need ad hoc judges. We need to increase the judges' age to 65. 62 is ridiculous. You know, today, with ages going up, with health being much better, 62 is no age. And you need to, frankly, rationalize the age of Supreme Court, High Court judges. Everybody gets the same age. Let it be the same age. Some people will go to Supreme Court, some will go to the Court of Appeal, some will not. But at least they have that adequate time, so they contribute to the system. Make judiciary more attractive for youngsters. See the kind of professional, at least in the metros or the mid-level cities, Tier B cities, the kind of professional satisfaction young lawyers are getting. A lot of them do not want to opt for a career where, supposing you want to become a judge, let's say in the High Court, you don't know your file may be lingering for 2 years. Why will you remain in that state of animated suspension? A colleague of mine, a very dear friend who is the sitting judge in one of the high courts, for no fault of his, was in suspended animation for 2 years and the file would keep moving. But because one person's name was being bandied back and forth, this gentleman for 2 years didn't know whether to wind up his practice or not to wind up his practice. And this is becoming an order of the day. And meanwhile, there is mental stress, there's physical stress, and beyond the point, it becomes little unfortunate. In Haryana, 39%, Punjab, 26%, posts in lower judiciary are vacant. This is the kind of numbers we're dealing with. And the other point is, we need to have an all India judicial service, at least in my view, to make judicial profession more attractive, like the civil services, where there is going to be a consistent opportunity. Merit is what is going to take you forward, not necessarily whether you've joined as a magistrate or the session judge or a high court judge, but merit is what should take you forward. Why is it, I ask myself, that we have had one judge in this country from the magistracy to reach the Supreme Court and just a handful of judges from the sessions or district judiciary, higher judiciary to reach the Supreme Court? These things need rectification and these need tweaking at a very serious level. Apart from the appointment of judges, the numbers, enhancement of infrastructure, I'll give you a statistic. In 2012-13, and this is one of my favorite numbers which I bandy about, I was part of an exercise when I was the government officer as an additional Solicitor General, where we added about 88 courts all over India, special courts for corruption cases. The result was criminal trials and corruption matters started getting completed in 3 months to a year. So if that can happen in one branch of law, why can't we have it in other branches of law? While we speak of this, there is one more thing I want to speak about, which is, do we ever do legal audits? Do we do audits of our legislation? Do we do audits of our system? The high courts bring out these wonderful booklets speaking about the numbers they've disposed of. And we have these maha or mega lok adalats. But what is the kind of offenses we are reaching? It's important. I'm not saying it's not important. But perhaps we need to try and expand the reach of lok adalat, expand the reach of mediation, expand the reach of ADR in its entirety, expand the reach and make pre-litigation mediation more effective. Only then will we get anywhere. While we do this, there is another point. Is it not time that we separate the administration functions from the court, from the judicial functions? The Law Commission in 98 suggested a National Judicial Center. Now look at the number of the load we put on judges. You started putting judges on administrative committees of everything. So I can understand judges being on rule-making committees. But judges are on committees which decide what car to be bought. Judges are on committee to decide what kind of glass to put in a building. All of this work is adding to the load of judges. And I will say one thing which I must also point out. Justice Kumar spoke about commercial litigation arbitration. I think it's very important. But somewhere along the line, we must not lose sight that the legal system, the legal administration, is to cater to the common man. To the litigant who is seeking a writ, or let's say, he just wants a water connection, or he wants the municipality to make sure that his street is clean. For the litigant who wants his liberty because he's stuck in some unnecessary litigation. For the litigant who has a rent matter and who wants possession of his house back. Or for the litigant who has a small claim that he or she has to make from another person and the matter is dragging. We have to also cater to that litigant. And that is something which, with the evolution of our legal system, we are losing sight of. But of course, nothing will be possible till we, that is the legal professionals community, discipline ourselves. I overheard one of the other speakers talking about limiting time. The ideal is we can. I'll give you a small example. In the Muhammad Arif case, in death penalty cases, I had suggested a time at that stage. There was a amicus in the matter, and the Constitution bench accepted that reviews in death penalties will have oral arguments, but 20 minutes each. That 20 minutes in practice has become now about 40 minutes each, because it's a death penalty case, so the judges like to give all opportunity. But the point is, we will have to now have a serious effort at time management. And the moment that discipline is sought to be brought about, we, the legal professionals, will also today, to be very honest, all of us end up taking more matters than we can, because we know that half the matters are not going to conclude unless you come across a judge like Justice Dhingra, who will catch Siddharth Luthra by the ear and make sure that he appears and does every matter. Barring, a lot of other judges are a lot more accommodating. Not that he wasn't accommodating, but he made sure that you did your work and you won't get away with an adjournment just for the asking. The point today is, and as I recall, sir, you did the fastest trial, I think in the Parliament attack, if I'm not mistaken, sir?
Yes.
Yes. Now, the point is, we will have to, as a profession, there has to be evolution, there has to be introspection, and there have to be guidelines through the High Court rules mechanism, which have to be followed as to time management, scheduling of cases. I mean, the smallest courtesy is exchange your judgments in advance and to the judge so things crystallize. Now, on an ad hoc basis, judges keep evolving their own methods, but we have to have an institutional response, and it has to be a response based on each high court is experienced leaving some play in the joint for the district courts because they know what their unique problems are. I mean, you can't have the same solution in Sikkim. In Sikkim, one honorable Chief Justice started deciding all the matters, and finally the lawyer said, sir, if you decide all the matters at this pace, within 3 months, there'll be no cases left. The High Court will have to be wound out. Please don't do that. That method can't be applied to, let's say, to Allahabad or to Patna or even to Delhi. So, as I said, these are some of the things which we need to look at. And therefore, a preliminary timeline setting is a measure which would help judges and litigants. We tried to bring in some reform through High Court rules in the criminal law guidelines where I and Mr. Basant, former judge, were amicus. The last thing which I want to just touch upon, last two things, and I will then leave it to you. The use of AI in judicial systems is now being applied by judiciaries, prosecution services, other specific domain-specific bodies all over the world. AI can be used for contract drafting, translation, legal research, also scrutinizing, small offenses like traffic offenses, negotiable instruments. All of this can be done, automated filing, case scheduling, and improving administration, pattern recognition, nature of biases and decisions, transparency, accountancy. All of this can be utilized, analyzed through AI, and we can improve the system. But for that, we have to be willing to put that time to learning. And for all of us, there is a lot more to be done. The National Judicial Academy is a very vibrant body under Justice A.P. Shahi. I'm really impressed the way he's running it. He's made me run around across the country, and right now he's going to be in Simla next week. The point is we have to start at the grassroots and make it training, not just for judges, but for lawyers as well. I'll tell you of an experience many years ago when Justice Deepak Mishra was Chief Justice, Delhi High Court. I was appearing for prosecutors, and it turned out that prosecutors didn't have computers, they didn't have books, they didn't have infrastructure, they didn't have stenos, they didn't have a room in the district courts. So he provided for a lot of that, but he also put a condition that we would start mandatory training for them. I remember that I was told by judicial order that I would be part of the first training, which I did. But after that, I don't know of more than one more training that has taken place in the last decade. The last thing I want to leave you all with a thought is, Justice Warren Burger, former Chief Justice of the United States Supreme Court, talked about judicial impact assessment. We have environmental impact assessment. We must also have a judicial impact assessment to understand how are judges going to keep with the plethora of new laws that we are adding all the time. We are becoming a highly legislated country. The reach of criminal law has gone beyond all compare. Today, every aspect of our lives from birth to death is part of some legislation or the other. It's necessary. I'm not saying it's not necessary. But somewhere there has to be streamlining of the laws, not just weeding away old laws which are no longer relevant, but actually streamlining and a legal audit of the laws and an audit of the judicial impact so that what is the kind of infrastructure we need to meet the challenges of the future, not just ad hoc responses. Example, Bihar. You had liquor prohibition. It led to clogging of the High Court. The Supreme Court came down with observations saying the amount of time judges are dealing with in just bail-related matters is making them non-functional. So therefore, I think we have to start from the beginning to the end and have a comprehensive review. We can't just keep tweaking the system as we have been doing. We keep seeking to tinker it at one place or the other, while the initial impact seems attractive, but what we're really doing is taking our resources from one place to the other. And like with our judges, when we say we'll make a special judge or a designated court for any particular time, what you're really doing is you're making the same individual wear multiple hats, but the individual remains the same. And that is, I believe, the most important redressal we need. Quality, trained, sensitive, efficient, and numerical strength in the human resources apart from infrastructure and AI. That, with respect, is the way forward. Thank you so much, Pavan, and thank you all for this opportunity.
Thank you. Thank you very much, Siddharth. You have very nicely covered and the quality, efficiency, numerical strength, infrastructure, AI, and you have rightly pointed out about the use of AI. And I think you have covered the whole point. You have not spared the community also, because you have given them a direction also. So thank you very much for your wisdom and your words which you have experienced in so many years. Thank you very much. You remember we studied and we were doing the moot court in the Campus Law Center, and various things are there. After so many years, we are interacting. So thank you very much for your.
When you were studying more, I was just doing moot courts and other stuff. You're the one who used to do all the hard work and hard studies. You are the bright student amongst us all.
That's right. That's right. Those who are the backbencher, they are on the.
You and my friend Nagesh.
Yeah, that's right. That's right. So thank you very much, Siddharth. Thank you. I know, despite of your busy schedule, you have come. So now come to you have referred Justice Dhingra. I have worked with Justice Dhingra in the tribunal also. So I can understand that he was always preferring no adjournment, and adjournment should not be the part of the system, and it should be exception. So now listen to Justice Dhingra, his point of view and his experience, which he has learned from the session court, lower court, and then the high court. Over to you, Justice Dhingra.
Thank you, Aman. My brother judges, panel advocates, and others. You see, I will not deal with the problems. You have already heard with the problems. I think it is time that we should come to solutions. You see, one solution which I have been, advocating for quite long at various forums is specialization at all levels of our courts. When we recruit district judiciary, we should give option, as we give in IAS, to choose the state. Here, we should give option to choose the subject. We should have jurisdictions: criminal jurisdiction, civil jurisdiction, family jurisdiction, commercial jurisdiction. We can divide the court cases into broad jurisdictions where the same set of laws are followed, and we should give this option to the judges that you have this there. It is not necessary that every judge should be jack of all trades and master of none. I can understand. You see, we have specialization almost in all fields: in engineering, in health, in look into any field, even in IT. See, in information technology, we have specialization in different fields. So if somebody is working on AI, he becomes specialized in AI, artificial intelligence. Somebody is developing software, he becomes software engineer and specialized there. Why can't we have specialization in judiciary? So once we have specialization at all levels, at all level means not only at district level, even at high court level, we should have specialized judges who should be dealing with the same kind of cases throughout their career in the high court. We cannot tell that judges will become bored by criminal jurisdiction. Now we shift them to commercial jurisdiction. Now they may have become bored with commercial jurisdiction. We shift them to this property or civil jurisdiction or intellectual property jurisdiction. So this kind of shifting of the judges and from one jurisdiction to other jurisdiction envisages lot of wastage of time. Lot of wastage, because whenever you are in the new jurisdiction, you will have to first understand the advocates who are dealing in those cases. You become actually an uneducated judge in that jurisdiction, and you are being taught by the advocates. While I consider the judge should be the most learned person whose knowledge should be much more than the advocates who are appearing before him. Today, the situation is reversed. Judge, as you see, advocates talk and argue as if judge knows no law. And the argument on small matter, on importance of section 161, 164, R151 CPC, R482 CRPC, they linger on for days together. Why? Because the advocate would keep reading judgment after judgment before the judge, and the judge would keep listening there with no restriction of time. So that kills the whole system. So unless we have specialization and unless we stop this roster system changing judges with every 6 months or every 3 months or with every case, we cannot do justice to the people of this country. What for this system has been evolved? After all, this system has to serve whom? This system has to serve the people of this country, and people of this country include 95% those people who cannot afford these high-value advocates. So I think the judges should be so much trained in law that whosoever be the advocate, the judge should be able to know the law and decide on the basis of it within no time. Why should he keep hearing argument for several days? So that is one reason that our judicial system is not functioning properly. I would like to remind you that Justice Bobde, in case of P.P. Pandey, he said we can say on oath that only 5% of time is being used for common citizens whose appeals are waiting for 20 to 30 years. This court has become a safe haven for big criminals and rich persons. You come here for 6 or 8 times for anticipatory bail, and we should hear as if we were a trial court. Now, this 6th and 8th time, they are coming before 6 and 8 different benches. You see, if the same bench is hearing, the bench would know what was the history, what was the decision given. They immediately recognize that this case has been already dealt with. They would dismiss the case at the very outset. And there will be no wastage of time. This roster is creating another problem. See, I like these cases, so I will fix these cases before me. Chief Justice is the master of roster in High Courts as well as in Supreme Court. He considers that he would like to decide this case. So he would fix those cases before him, because those cases may be of
जिगरा आपका
PILs are having such cases before one person or before a judge who likes to decide those cases is absolutely not required. They are not in the interest of this system. They are not in the interest of the nation. And this can be changed by the judges. You don't require a legislation by the parliament for this. But the judges are not interested. The advocates also enjoy this because they wait that, okay, now this bench, once this bench goes away, we will have another bench and we will try our luck before that bench. Mostly the advocates, you see, know the feeling of the bench, what kind of bench they have, whether this bench is strictly going according to law or this bench can take soft corners also. So this kind of practice is being adopted in our courts. Unfortunately, it is more adopted in our High Court and Supreme Court, where you see the judges by request get their roster changed, or the advocates Bar Association compel the Chief Justice to change the roster. They don't like a particular judge to be in particular bench, and they would go and say, please change the roster. So this change of roster so frequently, in some high courts I hear that roster is changed after 2 months in Delhi, and in some other high court is changed after every 5 months. And then they, because of this, we see lot of time is wasted. And every judge has to learn the techniques, run the law of his roster, de novo. You don't remember all the judgments. You don't remember all the cases, even if you have worked in that roster earlier. So that if we adopt this system of specialization, I consider that we will run at least double the speed at which we are presently disposing the cases. Mr. Luthra was talking that you see the High Court reports of disposal of cases, and their large number of cases are shown disposed. I think the reality is, if you go to the High Court report, in disposal of each case, they have taken 2 minutes. I was going through one Delhi High Court report, the total number of cases disposed and the time spent by all the judges together, the time for each case was 2 minutes, which is not practically possible. So what is done to show these statistics is that if there are 50 petitioners who have same cause and they have jointly filed a petition before High Court, they will give 50 numbers to that one petition, 2001 to 2051. And when they dispose one case, the disposal on the record is shown of 51 cases. This window dressing is being adopted by almost by all High Court to increase, to show the numbers. And similarly, in High Court and Supreme Court, the pendency number is so high because of this window dressing also, because giving numbers, multiple number to one petition. So that is one cause. Now I come to second major cause of delays and non-disposal of cases, which is adjournments. See, in 1976, CPC was amended and 71, CRPC was amended. It was specifically provided that busyness of advocate in another court would not be a ground for adjournment. Now, which court is following this mandate of the Parliament? No court is following this mandate of the Parliament. Neither High Court, nor Supreme Court, nor civil courts, nor trial courts. Why they are not following? Because this institution is, according to these two players, judges and advocates, meant only for advocates and judges. There is no third player in this institution. The third player, which is the poor litigant or the witness, has no space. You take priority, you give priority to cases at your own will. Why you have not made rules so far that what are the cases in which court can give priority? These rules should be universally applicable to all High Courts and Supreme Court. That it is not the will and desire of a judge to give priority to one case and throw the other case below. That is why Mr. Bobde had to observe that we are giving 5% time of the court to the common man. And to whom the priority is given? To those cases in which high-value advocates are engaged. What are those high-value advocates? Where either they have face value, they charge very high fee, they charge from 7 lakh per hearing or 5 lakh per hearing to 21 lakh per hearing. So there are clients who can afford, but think of the person who earns 15,000 per month. Can he think of assessing these courts? Can he think of even assessing a civil judge? where even the at trial court judges stage, the advocates are now charging fees per hearing wise. So even if they charge 1,000 per hearing, which I'm thinking is the minimum which any advocate would have been charging. I do not know actually what are they charging. But I know some advocates who are charging 11,000, 15,000 per hearing, even at trial court. So think of person, how can he think of approaching the court? If we say that filing of every case in courts is reposing of confidence in the judiciary, I take it worse. This is compulsion of the people that they have no other alternative. It is Tina factor. That where is the alternative? Where should they go? That if they do not go to the court, the other option is only to have lathi in their hand and settle the dispute, which is more dangerous than suffering the system. So police person should be more, number of administrators should be more, number of doctors should be more. We have less number of beds per million than in any other developed country, where it is hardly 20% of what we have in developed country. We have less number of doctors, we have less number of nurses, we have less number of police person, but no other system is saying that I will keep you waiting at the doorstep for 20 years because we are less. It is only judiciary which is not prepared to improve itself by at least improving internal mechanism. So this is now adjournments are given at drop of heads. Law provided that you cannot give more than 3 adjournments to one party during the entire life of case. And I do not know a case in which only 3 adjournments would have been given. At least, you see, when a case runs for years, decades, can you think of only 3 adjournments? CPC provide that once evidence starts, you have to record it day to day. This is followed more in defiance by judges. Why there is no penalty on judges who do not record day-to-day evidence? And when it is stated that the cause list is of 150 or 100 or 110, how it is humanly possible? Who prepared this cause list? After all, you have been adjourning cases and fixing those number of cases in one day. Why you are making your court master as master of your diary, court diary? Every judge should at least be master of his diary. He should know how many cases he can hear, how many cases he should fix. He should put it some time apart for the preliminary hearings, which new cases. And one court doesn't receive more than 10 or 12 new cases, which files reach the house of the judge every evening. He can come prepared with those 10, 15 cases. Rest are the cases which have been routing before him time and again. So, if you have increased your diary to 100 or 150, you cannot blame somebody else that now he is to be blamed that my diary is 150. How I can hear 150 cases? This used to happen. You see, when I used to be given a new roster, I also faced this problem. About 100 cases or 120 cases. For first 2 months, I had to sit late, work hard, and within 2 months, I used to bring my diary to 45, 50, which were easy number for me to handle. And I would not give adjournments. So, see, trial court also can do the same thing. Why should the trial court? See, there is another difficulty with the trial court. If the trial court doesn't give adjournment, the people immediately rush to High Court, even on the order of not giving adjournments. And the High Court, the common observation is of the High Court is heaven was not going to fall if we had adjourned this case. Actually, heaven has already fallen. We are denying justice to the common man and to the people day in, day night. You see, on adjournments, I think you remember a case where we were in appellate authority and we were assembling from all over India. And one party, both the parties appeared. One had come from Ahmedabad, other had come from Bombay. The advocate said, "I'm sorry, I'm not ready. I have been engaged only a few days back. I am new advocate." And we gave adjournment on calculating the cost of person traveling from that place, staying in Delhi. And we did not take into account the cost of the assembly of the members of the appellate authority. It was only cost of the other litigant, so that he would pay cost to the other litigant. And against this order, he went to Madras High Court and obtained a stay against the cost. Whereas law provides that whenever you take adjournment, the court can grant you adjournment in exceptional circumstances by imposing cost and even compensatory costs. But see, High Courts and Supreme Court consider that they are above law. No High Court and Supreme Court is following the rule of 3 adjournments. If they are not following, how they expect that trial courts will be following? And when the trial court has this agenda of High Court and Supreme Court, that if you adjourn, we will adjourn. So this is happening with trial courts. We have to first look into ourselves. Are we serving the people? Are we serving ourselves? I can understand that advocates are professionals. They are working for fee. But judges are not professionals. They have joined the judiciary for public service. They are public servants. Technically and legally also, judges are public servants. If they do not serve public and they serve their own interest or serve the interest of their brother advocates, that okay, this is, you see, I have come out of the advocates. So I have been also seeking adjournment. Now it is his turn. Let him seek adjournment. So that is one reason. Now third is recruitment. We are recruiting judges at High Court and Supreme Court, High Court level, 66% out of the advocates. I'm not going into who is being recruited or not, whether the method of recruitment is good or bad, because that is another topic. The trial court judges who have experience of long experience of trials, they hardly get chance to go into to reach High Court, and those who reach, their service in High Court is hardly 3 years, 5 years, 7 years. That's all. There are very few who can make a mark in the High Court. So those persons who have been actually doing litigation at grassroots level, they are not given chance to come to the High Court and serve High Court or Supreme Court show their ability that justice can be done to the common man also. We have under Indian Constitution, Indian Judicial Service provision. And most of the High Courts have not agreed to this Indian Judicial Service implementation. Even the governments have also not been willing. The states have not been willing for Indian Judicial Service. What is the reason of their not being willingness to Indian Judicial Service? Because this system suits them. If they have a case, because they are in power, they can get the case decided early or delayed according to their will. And if they have power of recruitment, they can recruit judges according to their choice. This was happening before collegium system was there. I was working in, Competition Commission of India, and one of my colleagues had been secretary to the chief minister of his state. He said when names of some advocates came, he objected to some of the advocates that these are known corrupt advocates. Why you are sending their names for High Court? He said the chief minister told me that these are the persons who will help us when we are in trouble, when they are in High Court. So that is the criteria of choosing. And the other criteria is well known to everybody. It is nepotism. You are my brother-in-law. You are my, sons. That way, a few 100 families are there. Almost 100 families, out of which judges are chosen. Where does a poor man get chance to go to High Court? A common advocate doesn't get chance to go to High Court or Supreme Court. He who knows the pains of the common man has no chance to go to High Court or Supreme Court. And those who have only lived in luxury and gone to those high value colleges or foreign universities, they are connected to the well-to-do families, are connected with governors or High Court Chief Justices, Supreme Court Chief. They get chance to go to this. The whole system is suffering because they don't have an idea how much a poor man, what poor man requires. See, they have an idea how I will get publicity. So this kind of, so these three, one more step, which will reduce the pendency greatly, is video recording, video and audio recording at all levels of judiciary. Started from magistrate, right up to Supreme Court, all recordings should be there, and you should look at what has been argued from the audio recording. And you will also know how much a judge is performing. Now the situation is that in trial courts, in one court, 3 courts are running. The judge is recording his evidence, the reader is recording evidence, judge is hearing argument, and on other side, the steno is also recording it. So 3 courts, and sometimes judge is sitting in the chamber and the evidence is going on. So if audio video recording is there, you can have this system within these means, within these resources, you can make the system work in a better manner. One more suggestion I have. You are going to, you see, digitization and all that. No trial court record should be called to the High Court or Supreme Court. If the record are digitized on the flick of your computer switch, record should be available to you. Why you stay the cases that the record is to be called from the trial court shall stay the hearing. So I think we have means, but we don't have willpower. So that willpower should be there and we can do that. Thank you.
Thank you, Justice Dhingra, giving suggestion on expertization of judge to adjournment to digitalization and video recording. Very nice suggestion, practical suggestion. We'll compile all these things. Now, over to you, Mohit, because you have to go for another program. So we just want to listen from your side because you have more responsibility as a Bar Council President of Delhi High Court, which is the most prominent High Court in India. So your views, Mohit.
Thank you, Pavanji, Justice Dhingra, Mr. Nagesh, Siddharth, Mr. Ravi Prakash, and all other panelists, and good evening to all the attendees. I was hearing Justice Dhingra's suggestions, and I was only feeling that perhaps most of the suggestions which we could give have already been taken care in extenso and in much detail with all the live examples with Justice Dhingra's experience. Only thing is where I beg to differ is where Justice Dhingra was castigating senior counsels and lawyers and passing on the buck, because one point which he was right, that the two stakeholders, the bench and the bar, go hand in hand. So if there is some kind of a allegation coming on us as the lawyers, I think equal would go to the bench as well. So rather than thinking about why these things happen, the topic for the day being how to reduce, certain suggestions where sir has said are right, but just to add a few, there had been a long discussion, and last year also this came into prominence, was appointment of ad hoc judges. Now that is an aspect which needs to be seriously considered, because the retirement age being 62 and 65 in High Court and Supreme Court, and most of the honorable judges post-retirement are still working. Why not utilize their services for the cases which have been pending for very long? And this had happened earlier in the past when Justice Jayachand Reddy, and Nagesh Bhai is there, I'm sure he will vouch for that incident when Justice Reddy was appointed immediately post the retirement, and the bench continued. A division bench was constituted in the Supreme Court only to deal with all the old regular criminal cases. And for 1 year, when Justice Reddy was there, the appointments, the disposal was so much that the pendency was brought to the near minimal. Now, with the amendment of 224 capital A being brought in, the same can be done in the High Courts as well, and it does not affect the strength of the High Court and the appointments of the High Court. It doesn't occupy, an ad hoc judge doesn't occupy the permanent strength of the or the additional judge's vacancy. So that is one aspect which one can look into, and the government should look into it. Last year, there was a long debate about it. Chief Justice of India, Justice Ramanna at that time, had also voiced this. And I don't know where it is lost thereafter, but this is something which one can look into. Another aspect is, where again I beg to differ from Justice Dhingra, is on the fact that the judge should know more than the lawyer is probably not the right notion which one should step in as a judge. Because he should be able to see what the facts are and then see how best justice can be done. In that regard, an open mind is always better to decide. Otherwise, as he rightly said, one would be still trying to avoid all the bench. That bench, whenever it is sitting, they will avoid it. So I don't think that a closed mind is better. But yes, I definitely borrow from Justice Dhingra's suggestion that specialized judges should be there, because they will obviously act faster, their disposal will be faster, and they'll be able to handle a situation far, far better on the particular subject in their specialized field. And there's nothing wrong in it when you have specialized judges. Since law has to be dynamic, one should consider the situation that is happening in constitution benches. And that is allotting time. You don't go on for eternity. Don't keep on arguing for eternity. You are given a slot. And in that slot, you have to conclude your arguments. Conclude your arguments with probably a synopsis of your arguments being handed over in advance or even immediately on conclusion, which actually helps. Another suggestion to that is also by what the speakers have said, video recording. Justice Dhingra just said, that will help you in remembering what or recalling what has been argued. But at the same time, I feel it also, a synopsis also helps in understanding what the lawyer wanted to say, because he may not be able to utilize that much time in speaking, but when penning it down, he may be able to explain it much better along with the authorities that he wants to rely and which paragraphs, etc., to support his arguments. That's one thing which I feel helps. Another aspect is which I feel is you have to give more emphasis to pre-litigation disposals. And pre-litigation disposals, as have come out in commercial courts as a mandate, can be extended to other jurisdictions as well. Because that pre-litigation, the kind of conciliation or mediation or some kind of a mechanism will help in at least the petty crimes or petty cases being thrashed out at the threshold itself and then disposing them off. That helps in reducing the load on the courts. It helps in reducing what goes to the court for unnecessary litigation, because sometimes outside the court, there is better bonhomie, and inside the court, you are restricted by the contours of law. And you are also governed by what the law allows or permits. Because many a times, and I am sure the other counsels and judge on the panel all can accept this fact, that all the laws are prohibiting certain things from being compromised and settled also. When you are codifying what can be settled and compounded, you are basically leaving the others outside that realm. And that is an aspect which can be considered, opening that fora for such kind of pre-litigation settlements, or some kind of what I would not say a plea bargaining, but something of that nature, where you compromise cases, compound cases, which can be so done, rather than invoking a lot of cases. Because today we find that almost 30% of the cases which are clogging the board of the criminal side, we know as a matter of fact, are cases which can be all sorted out, which relate to offenses which are not so heinous, in fact, less punishment than 3 years. I'm not talking of all the serious cases, but yes, these can be done. And one aspect which I want not just the panelists to consider and all the attendees to consider, but I think even the people sitting on the bench, both in the high courts and Supreme Courts, is to trust your subordinate officers and subordinate judges. Have faith in them. Give them that assurance that their orders are not to be touched lightly. And the minute you do that, the confidence level will increase and you will find a far better quality. Because what is happening today is an easy rush to the superior courts, and superior courts time and again and erratically and randomly sometimes passing remarks, which actually are just passing remarks, but they unnecessarily affect the psyche of the judicial officers and the lower court judiciary. That's the basic pedestal of the pyramid. Now, if you give strength to your magistracy, your session judges, your district judges, judiciary, give them that confidence that their orders are equally sacrosanct and they're not going to be lightly touched. You will find that the burden of the courts will reduce, because if they are confident that their orders have some meaning, some effect, I feel lawyers will give them that much due respect and not challenge those orders. And in turn, one case will not translate into 10. One case will remain 1 or maximum 2. So the pendency gets reduced in that manner. Other aspects have already been touched by the speakers. This is something which I have been voicing as a member, as a representative of the bar, that we must give the due credence, and because these judicial officers are the appointees of the superior officers, they are not just appointed, they are basically nurtured also, and it's our duty as the bench and the bar to nurture them to become better judges. And then in that matter, in that respect, we'll be able to somehow help the institution, the legal justice system, the justice delivery system. It will all be better. That's my take on things. Thank you so much.
Thank you very much, Mohit, for giving a suggestion on appointment ad hoc judge.
Thank you for giving me the opportunity, Pawanji. Thank you.
Litigation. I know you have to go for another program. So thank you very much for giving me valuable suggestion. Pre-litigation disposal is a very important, very effective, which I was echoing also in my presentation. Now, let's listen to the ex-additional secretary of Law Ministry and the ex-member CCI, because she has worked on the various legal committees and legal aspects. Over to you, Mukhlita madam. You have to unmute yourself, madam.
Thank you, Pawanji. I thank Corporate Professional for organizing this 125th webinar to help the corporates and other persons, other professionals to have the capacity building as well as to reduce the areas of the court cases, because by these webinars, you are informing the public about the law, about the problems. Your presentation highlighted the volume and acuteness of the problem, and that speaks of judicial emergency. We have judicial emergency now. We have to declare this. And I think the system we have followed, so before independence, I think now it is not matching with the requirement of the society. That speaks of that. I thank Mr. Pongwar Vijay, respected Honorable Justice Alok Mathur ji, Honorable Justice S.N. Dhingra ji, Honorable Justice Sandeep Kumar ji, and other panelists of today's program, and the learned participants who have joined this program, this webinar. सभी विद्वजनों को, भाई बहनों को मेरा नमस्कार. आई एम वेरी हैप्पी दैट कि आज कॉर्पोरेट प्रोफेशनल ने एक बहुत दुखती रग को टच किया है, और जनरली गवर्नमेंट हो या प्राइवेट पर्सन हो, all people avoid talking on this issue. There has been a law commission, and law commission was constituted in the year 1834, and Mr. McCullough was the chairperson of that law commission. Since then, law commission is continuing, but it is not a statutory body. We have till date 22nd law commission, and whereas law commission reports may be 77, maybe 79, maybe 245, 88 or 124 or 245. Because of shortage of time, I will not name the title of those reports, but all those were dealing with the areas in the trial courts, in the high court, or pendants in the Supreme Court. Even in addition to that, we have other reports also. Criminal Procedure Code, on Civil Procedure Code. Even we have a report, and on the, I think in the year 1988, 131st report, role of the legal profession in the administration of justice. So there have been reports, and even before adoption of the Constitution, in 1949, there was a Rankin Committee to discuss about, deliberate upon, and make recommendations regarding reducing the areas in the court and for having speed and economical justice. So this is not the problem of today. It was realized way back in 1949, even before adoption of our Constitution, 1924, before adoption of our Constitution. And thereafter we had 1949 committee for reducing the high court cases. And thereafter we had number of committees in 1967, in 1969 also, committees were constituted, chaired by Justice Hidayatullah and chaired by Mr. Inadequacy of judges. And in 1967, government noticed that inadequacy of judges ratio, that is the main reason. Fine. Thereafter, the number was sanction and strength was increased, but still we are having the problem. So still we are not away from the areas. Why? Daily we have a new enactments, and as with the new enactments, we have cases instituted. So more the enactments, more the filing of the cases. So how to prevent that? I think then only we can reduce the areas. Because I'm from a drafting department, I have dealt with the drafting of laws, and while drafting, I noticed that language is very important. A language which can be understood by a common man. But I think since independence, we are having, as per the provisions of the Constitution, we are having, the law is first drafted in English language. Then its authentic text is translated into Hindi. The person who drafts and the person passing in the parliament, The expert committee recommending for the enactment of the code. Thereafter, administrative ministry initiating the note for the cabinet, coming to the law ministry, and thereafter going to the parliament. I think intention of enactment of the law, I think varies from institution to institution. When it comes for implementation, then also the person who implements, I think section level officer, block level officer, panchayat level officer, as far as the public utility or other probationary officer in the banks, do they understand the language of the law? Do they understand the statement of objects and reasons of the law? No. So government is the biggest litigant, I do agree. But why? Government is the employer of number of employees. And then why litigant? Why in government there is a litigation? Why can't government provide justice to the employees? So here comes a question of executive justice. When the law is implemented and persons are not satisfied, aggrieved, they don't get their due through executive actions, certainly they approach the court. So problem lies at the level of the executive justice. Many boards, many quasi-judicial authorities, means there are in the government. Why they are not doing justice there? Why people are approaching courts? Because being a government is a juristic person, not a personal accountability. If they do so, okay, let him go to the court. So when a person, he is not feeling that when a person goes to the court, it affects ease of living. It affects daily livelihood. It affects even for a corporate professional or a government employee. That very day, he is not able to give that efficiency or excellence in his office because he is filing litigation. Why people are unsatisfied? When we have a rule of law, and the rule of law means everybody is entitled to the same rights. Then when the rule of law we have and we enact the law for that, then why unsatisfaction? I think nobody has gone to that extent. As far as the judicial impact assessment is concerned, I just bring to your notice that in 2002, M.J. Rao committee was constituted to study the judicial impact assessment. If this law is enacted, how many cases that law will generate and how many judges it will require to dispose of those cases. And in Salem Advocates Bar Association also, this report was discussed at length. And I think Salem Advocates Bar Association case, Madras High Court, and M.J. Rao committee report, I think it speaks a lot. And we need to do so, judicial impact assessment. But why executive justice, if it is smooth, I think inexpensive, then what is the need of CAT? We have tribunals, we have courts of various layers, appellate courts of various layers. We have arbitration system, we have Jan Chopal, we have Lok Adalats. Still, so many pendency. More the people are educated, more they are vigilant about their rights, they file suit. They file applications. I think somewhere something lies. And to my point is that drafting should be in a simple language, unambiguous language. When Parliament has passed the law, it should be in very, very unambiguous language. The section officer or any senior officer of the government or any member of the public interprets the same. He interprets or he reads in the same sense, the way the judge will read. So interpretation of law, the law is settled not by the enactment by Parliament, but law is settled when it is interpreted by the Supreme Court. And then the justice becomes so expensive because at the first court of first instance, I think, व्यक्ति कहता है कोई बात नहीं हार के जाएंगे हाई कोर्ट अपील में because you have a luxury to do so and it has become luxury. I know that Justice Dhingra spoke about adjournments. I won't name the citation of that case. But in that very case, stay was granted and after 9 years, there is a stay, a roster because of change of register, no opportunity of hearing. I know about that case. And that was a government case because I'm in government and I know that this case is going on and no justice. So here we have to look at the problem. Government has to undertake intensive awareness campaign about the law because rule of law society, let us make up the people that they abide by law. They religiously follow, adhere to the provisions of the law. unless the government focuses on this issue, because sometimes what happens, you are not informed of the law, the other is informed. So the person who is not informed, he feels that I'm aggrieved, and he goes to the court for the simple reason that there was no awareness campaign. Intensive awareness campaign of the laws should be undertaken by the government before enforcing that very law. So that government has well informed. Intensive awareness campaign on the media, I mean print media, maybe audiovisual system, but there has to be. Maybe educated, maybe non-educated, but at least they have the opportunity. And we have a system that we pass the law, we pass the ordinance, we promulgate the ordinance, and we just complete that notification by serving 5 copies of that ordinance in public or to the government departments. With that, government, every member of the public doesn't know what is the law. I think somewhere this problem needs to be tackled, because we have to regularly publish its bullet points, and we should, I think, disseminate or give to the level of panchayats so that they also know. In all cases, not about all laws I'm telling you, but all cases dealing with the public utility, we should have a help desk system. In every office having public utility services, maybe bank, maybe insurance, maybe municipal corporation, public utility, maybe even a tribunal, some help desk system, so that a person may come and the paralegals can be engaged so that they can know that there is a problem or there is not a problem. It is only a matter of interpretation, and that person doesn't know about the law, that's why there is a problem. So we need to have good cadre of paralegals. The way in medical we have medicals and their diagnostics, so that the doctor see the diagnosis, see the path lab reports or other things, and then he decides what medicine to be prescribed. Similarly, the paramedicals can be utilized to help reduce the burden of cases, because preliminary sorting out, they will do it. So they will reduce or they will cut short the time taken by the judge or adjournment granted by the judge. So number 2 is that we need to extend the scope of arbitration. It is only up to civil matters. But Justice Dhingra rightly said that again we have to rethink over how can we reduce the burden. If arbitration is made compulsory, the way when a writ petition is filed, we say that alternative remedies have been exhausted. Similarly, in all civil cases, we need to say that you can approach the court only when arbitration, mediation, and counseling has been exhausted. Otherwise, we will not entertain this suit or this application. So arbitration scope needs to be increased. Again, it needs to be reviewed. Can we reduce the burden of cases to this? Thirdly, we need to reduce hierarchy of courts. We need to have full stop. First appeal, second appeal, then Supreme Court, civil magistrate, then the Sessions Court, District Court, then the High Court, then the Supreme Court, then the special petition. What is all this? That means the person who is dealing first time, he has not done justice. He has not done justice, and he is not responsible, accountable, because he knows that person who is agreed, he will go to this. Have we made some, I'm not saying accountable because judiciary is independent, but it's so a state wing. And without justice, no society can flourish. Democracy can't sustain. If there is no, justice system, delayed justice. Justice done, fine, very good judgment. But what about quality? Delay dilutes the quality, because the person is no more, or now he doesn't want that benefit because he has already acquired through some other means. So delay is the biggest problem, and delay because new cases are going on, so pendency is there, and the old cases are not being disposed of. I think point is about the judge and case ratio. If there is awareness campaign and the people are, both the parties are aware, I think that will reduce the burden a lot. And the laws are drafted in Hindi. Arguments are done in Hindi. That movement has taken off. It has been taken over by the government, and courts are doing. And the litigant should have the opportunity to understand what he is speaking of. Can I help? And I think they can themselves argue. If it is in Hindi, they can argue. ये fact नहीं, ये fact है. Thirdly, we have a number of studies about many reports and government committee reports also. But point is that a litigant can best feel the grievance of delay. Have we consulted litigants? Have we consulted litigants? No. Any law is enacted or any law is drafted, have we consulted the grassroots level person who will be having the benefits or who will be enjoying, or who will be the beneficiary of this law? No. Representatives, they are well off. Representatives are well off. So, I mean, you call as a committee member or expert member, but have you done that? We go there and see on the spot. See on the spot what is the problem. This has not been the procedure for drafting of the laws. आपको यदि कृषि कानून बनाना है, कृषि मंडी में जाइए, कृषि के पास जाइए, खेतों में जाइए, आप देखिए उससे कितना मेहनत करता है और उसको क्या मिलता है, कितना बीज बोता है, शायद वहां पर गैप है. एंड दैट्स व्हाई एग्जीक्यूटिव इनजस्टिस. जो भी लॉज पास होते हैं, जुडिशरी पास करती है, पर शुरुआत में उसका पायलट तो करती है एडमिनिस्ट्रेटिव मिनिस्ट्री. सो एग्जीक्यूटिव जस्टिस, आई थिंक उसको वहां सुधारने की जरूरत है, सो दैट पीपल डोंट अप्रोच द कोर्ट. उसके बाद सेकंड नंबर है कि आर्बिट्रेशन को मैंडेटरी करिए, सो पीपल डोंट अप्रोच द कोर्ट अनलेस दे एग्जॉस्ट दैट रेमेडी. थर्डली है गवर्नमेंट में एक ऑब्लिगेशन है, एक्सेस टू जस्टिस एंड स्पीडी जस्टिस. ये मौकरी बन गया है, फंडामेंटल राइट है. Whether government has done something to secure these rights? No. आप उस access to justice कब होगा? जब आप informed होंगे ना, तभी तो होगा. आप किसी गलत कोर्ट में चले जाएंगे तो वहां पर आएगा कि नहीं आप ये jurisdiction कोर्ट का नहीं, आप वहां जाइए. Similarly, यदि लोग informed नहीं होंगे तो ये cases बढ़ते रहेंगे. और educated society, इतना education पर खर्च हो रहा है देश का, क्या हम बेसिक मोटे कानून क्या हम हायर सेकेंडरी लेवल पर नहीं पढ़ा सकते, सो दैट जो बच्चा बाद में इंजीनियर डॉक्टर बनता है या वो जो बनता है या कोई बड़ा ऑफिसर बनता है गवर्नमेंट का, वो ऐसी गलतियां ना करे. क्या हम कोई डॉक्यूमेंट्री बना सकते हैं ये गलत इंटरप्रिटेशन से ये इनजस्टिस हुआ है? क्या ऐसी डॉक्यूमेंट्री बन सकती है जो लोगों के इमोशंस को हिला दे? अभी मूवीज तो बहुत बनी है, हर एक पर क्रिमिनल पे बन रही है और बड़े बड़े स्टेट्स में बनी है, पर किसी लिटिगेंट के ऊपर मूवी बनी है कि उसकी फीलिंग क्या हुई? क्या डाइवर्स केसेस में देखा है कि डाइवर्स केसेस, सोसाइटी पढ़ी लिखी है, उसके बाद में इतने सारे डाइवर्स केसेस, डोमेस्टिक वायलेंस केसेस छोड़िए बाकी बात. तो मेरा एक ही मुद्दा है कि ड्राफ्टिंग पे ध्यान दिया जाए. अभी एक छोटा सा ड्राफ्टिंग का फ्लॉ बताती हूँ मैं आपको. आई एम नॉट क्रिटिसाइजिंग गवर्नमेंट एट ऑल because nobody is perfect, but recently I noticed in some laws the use of word inter alia. We can use similar means whatever we have stated earlier, similar to that, but when we state inter alia, then law is not certain. Inter alia, it may include number of things, and that may give rise to its ambiguous language. So I think there also government needs to focus to train the drafting persons so that they draft, they understand that very language, and to draft in a present tense, not in future tense using should and would. Should means advice, would means future, law is always present. So socio-economic impact has not been studied. Okay, what is the socio-economic impact of this? We just say reducing court areas, लोग परेशान है, ये नहीं होगा, नहीं. It has a far-reaching impact, ease of living and ease of doing business also. So that needs to be looked at, and the whole system needs overhauling. अब वो सिस्टम जब ब्रिटिश का था, वो मैच आज की रिक्वायरमेंट से नहीं हो रहा है, बिल्कुल नहीं हो रहा है. तो शायद हमें स्क्रैच से दोबारा शुरू करना पड़ेगा. I just recall that in ancient India there are only 18 category of cases, just 18 category of cases. How many category of cases do we have? Number of tribunals, courts, number of statutes we can count. So less number of 18 cases. Human beings are same. Only corporate activities have increased. Otherwise human beings are same as they were in ancient India. Feelings are same. Requirement is also same. Maybe a luxury or lavish life is different thing. Basic requirement is same. So with these words, I would like to conclude with the wisdom words of Lord Krishna. Tasma Shastram, it is in chapter 16, shlok number choice. Tasma Shastram Pramanante Karya Karya Vyavasthito Gyatva Shastra Vidhanoktam Karma Kartu Mahasi. कर्तव्य अकर्तव्य की अवस्था में शास्त्रीय प्रमाण है ऐसा जान को तो शास्त्र विधि से नियत कर्म ही करने योग्य है। और शास्त्र कौन सा है? हमारे सारे कानून शास्त्र हैं। यदि हम सबको ये बताए कि यही शास्त्र है और आपको यदि गीता का पालन करना है तो आपको शास्त्र में जो कुछ उल्लेखित है उसके नियम के अनुसार चलना पड़ेगा, तभी हम कह सकते हैं वो गीता के अनुसार चल रहे हैं और तभी आप धर्म के अनुसार चल रहे हैं या राइट पाथ पर चल रहे हैं। With these words, I thank corporate professionals, all the panelists, and I had the opportunity to listen judges and the other senior advocates. And it was a great opportunity that I could come to know about the other facets of the problem. Thank you very much.
Thank you very much, madam, giving the basic idea that at the time of drafting, if you can conclude and if you can focus, then so many problems will not come. I think this is a good suggestion which we can jot down. Now, over to you, Nagesh, because I know we are exceeding time, but your practical experience and your things, please tell us.
Good evening, Justice Aloknath ji, Justice Sandeep Mathur ji, Alok Mathur, sorry, Justice Sandeep Kumar, Justice Dhingra, Vijay Varghese, and my friend Siddharth, Mohit, and Pawan. This topic is of so importance that I think Pawan misjudged the time. He gave only 2 hours. I think even if he had given one more edition, people would have explained in detail and brought to the attention of all the listeners how to reduce the burden of cases in India. I do not want to duplicate what has been said already by the esteemed speakers. I would limit my focus to the issue relating to the court cases which are pending before the NCLT and NCLAT only for the moment, because others have spoken widely about the pendency in the various courts, including the district courts, high courts, and the Supreme Court. See, what has happened in NCLT when it was made functional in 2016, I think under the Companies Act, the time that was being taken for winding up a company was almost to the tune of 4.3 years. So with the introduction of IBC, it came down to 340 days. So coming down to 340 days from 4.3 years, it was a great step towards reducing the pendency of resolving a particular issue under the Companies Act. But then what happened after that? Our experience has shown that though the picture was very bright, gradually the pendency, the time taken for coming up with a resolution plan or a liquidation went from 340 days to 715 days. So almost double. So within a span of 3 years, the NCLT doubled up, and there is also backlog around 20,000 cases pending in NCLT. So what the main reason for this backlog is, in my opinion, is A, the non-appointment of members. See, the sanction strength is 63, whereas we have only 36 members. So that is one of the major reasons for the pendency. And today, if you see, most of the NCLTs are functioning with half of the members, and they're doing 2 different courts on the same day. That means if a member is having around 30 cases, he's able to handle only 10 cases. The remaining 20 cases are getting adjourned. Not that he doesn't want to do it, but because he doesn't have the time. Because he's given only half a day to do his cases, the remaining half day he has to do for another court. So therefore, the importance to bring down the pendency of cases, in my humble opinion, is that there should be an immediate increase of the strength, and at least the sanction strength of people who have been there, they should be appointed. There should not be any delay in the appointment of the sanction strength. Now let me give me one more analysis. Today, if the entire 63 members are appointed, how do we decide this 21,000 of backlog of cases? So, in my opinion, what we should do is, at least on the administrative side, somebody in the NCLT or the NCLAT should, what we call it is, they should identify similar cases, bring it before one particular judge and complete the process so that the time taken to complete the process is reduced. B, the company law jurisdiction was diluted drastically with the introduction of IBC before the NCLT and NCLT. And company cases were not given their due importance at all. And therefore, we had to go and approach the tribunal president and the chairperson to say, sir, please at least have one particular day dedicated to hear the company cases, which was done. And in the process today, we are able to see that even the company cases are being heard and the pendency reduced. So this is one of the major steps. So ultimately, it boils down to what? It boils down to giving the hearing. And that hearing should be given for the purposes of reducing the burden of cases. And that can happen only when there are sufficient number of members. Lastly, we have this, as Honorable Justice Dhingra said, that we needed specialized people. So obviously the tribunals were created to be manned by specialized people. That is, people with specialized knowledge of corporate laws. And therefore, if those kind of people are appointed, we need to see whether he is having a expertise in company law, expertise in finance, expertise in recovery laws, etc. If those people are manning, it would not be difficult for them to handle a case and decide it at the earliest, which is not happening for the moment. Therefore, I'm requesting that we should have enough number of law researchers to be given to each of the members, which is there at the present. But I think this should continue to even the district courts. I think every district judge in the country should have one law researcher who will be able to help him in coming up with, giving help in providing him with assistance of case laws, etc. What is the latest case law that has been decided on a particular issue, so that he can come to a conclusion and reduce the burden. And lastly, I don't want to take much time because we already short the time. I think another major issue which we have to concentrate is the filing of interlocutory applications. I think we have not dealt with this. I think the speakers have also spoke about adequacy, representation, all that. But in my opinion, interlocutory applications are also one of the most important reasons why we are having a lot of cases pending in the courts. When the IBC was conceptualized, nobody realized that there would be so many interlocutory applications that would delay even the approval of a resolution plan or the liquidation. So these interlocutory applications are the ones. Why would the interlocutory applications come in if every stakeholder performs his duty correctly? For example, under the insolvency law, if the resolution professional performs his work properly, there would not be the necessity of any interlocutory application being filed before the court. So therefore, each one of the stakeholders, be it a lawyer, be it a resolution professional, be it a liquidator, be it a tribunal member, if they perform their respective jobs perfectly, correctly, the interlocutory applications would be reduced. Nobody would file an insolvency resolution, the interlocutory application. So therefore, every stakeholder, if he works properly, I think the burden of cases would come down because the interlocutory application would come down. Number two, we must also realize that the burden of court cases in India is not only relating to the matters which are ripe for final arguments. There are many cases, I think more than 25 to 30% of these cases would be for completion of pleadings. So let's also understand that we are talking about, when we're talking about number of pending cases, they're also including number of cases which are awaiting the completion of pleading. Somebody files a petition, reply, response, rejoinder, all that, they are awaiting. But this takes almost 2 to 3 months in each of the courts. So therefore, time management should be there for completion of pleadings. And once the cases are ripe for arguments, I think it should be given to a specific judge who can complete it within a time-bound manner. Hear the petition on the same day or the very next day and give a decision. So these are all important steps. See, we have seminars, we have so many issues. Everybody has a different take on how to reduce the burden. But practicality, we should also see that these are the things which everybody should take care of in the process so that they can reduce the burden of the cases. And in my opinion, especially in the tribunals, if these kind of steps are taken, it would not be a time where the tribunal, the number of cases come down. Lastly, I'll give an example. See, our Honorable NCLAT is chaired by former judges of the High Court, and the chairperson is a former judge of the Supreme Court. So we had some statistics which is important. In the quarter beginning from July to September, 700 appeals were filed, and out of the 700 appeals which have been filed, 750 appeals were disposed of. More appeals were disposed of than what have been filed. How did that happen? It happened because you had a very specialized person sitting and manning and deciding the cases without adjournments. Nobody sought any adjournment. Matters are taken up on the very next date, decided. So ultimately, what I'm trying to say is that there should be a mutual, a kind of a dedication to both the judges as well as the lawyers to complete a case within a time-bound fashion. And that will reduce the burden of the cases. So that is, in my submission, that's all important. And therefore, all stakeholders should do their duties perfectly to reduce the burden of cases. I'm not getting into many other issues because most of them have been spoken to already. And I wish we had some more time so that we can easily explain things to explain things in more detail. Okay, thank you, Pawan. Thank you for giving me this opportunity. Thank you. You're on mute.
Thank you, Nagesh, for giving valuable suggestions, especially on NCLT and NCLT. And you have rightly pointed out non-appointment and the law researcher. These are the certain important aspects. And interlocutory, that's also an important aspect which you have mentioned. So thank you. Our last speaker is Ravi. Ravi, you have very less time. So just give your suggestions on, directly come to the suggestion.
Yes, very good evening, sir. In fact, speaking at the last has its own benefit, but the perils are when before you have spoken justices and stalwarts like Mr. Luthra, Nagesh sir, and Mr. Mathur. And particularly the suggestions given by Mr. Luthra were radical. And if implemented, they will certainly help us in bringing down this clog which we face today. One of the aspects, it is a little aspect, but must point it out. 92% of the net expenditure of the judiciary is borne by states. And the data says that except for Delhi and Chandigarh, hardly there is any state which spends more than 1% of its total annual expenditure on the judiciary. If you see the total expenditure budget of 2023-24, the Ministry of Law and Justice is allocated roughly about 0.1% of the union budget. And there are news reports which say that over 50% of the Law and Justice Ministry's budget is spent on election-related expenses. So therefore, we clearly see where the scarcity of resources come from. But from what I did while I was listening to all the speakers, I collected all the points. And the points run from filling up of vacancies through ad hoc judges, infrastructural advancements, and use of new age technologies. These are these 3 points which former Justice Rohinton Falli Nariman also said in one of his speech in 2019. You also mentioned about use of ADR and pre-litigation disposals, and it was emphasized by Mr. Mathur. Standardization of procedures, specialized cadre of judges, arbitrators, advocates, and their periphery. And on top of that, their constant training, reduction of adjournments, revamping of the legal education system, time management, and on top of it, and probably which is the most scathing problem that we face today, is the verbosity that creeps into the system every now and then. And in my opinion, at all levels in the judiciary. if these are, and this is the low-hanging fruit, reduction in the verbosity, while all other measures may require some radical measures, some radical steps to be taken to reduce the pendency, the verbosity is a low-hanging fruit which we can immediately tackle, and it will give instant results. So that is also in view of the time. And lastly, the simplification of the myriad of laws, that will also help a great deal in curbing down the pendency. That's what I feel. And it is not, and it is an aggregation of thoughts which has flown into the program by the learned speakers. I just reiterated them all.
Thank you very much.
Yes.
Yeah, you. So thank you very much, Ravi, for giving the few different suggestions which other people have given. So it's a time to end this 125th webinar. Friends, we have already exceeded time, so that's why I'm not taking much time now. So on behalf of corporate professional, I thank Justice Alok Mathur, Justice Sandeep Kumar, Mr. Siddharth Tulkara, Mr. Mohit Mathur, Justice S.N. Dhingra, Ms. Muklita Vijayvargiya, Mr. Nagesh, and Ravi Prakash. Friends, today we have seen there was a advocates, there was a judges, there were ex-judges, there's a legal department person, and there's a practitioner. So we have tried to give suggestion from our side on different facets of the court process and the legal system, how to improve. And I hope that all these suggestions which we have received today, we will compile it and give it to the government and the judiciary also. The way we are giving earlier suggestion also to various regulators. So I thanks everybody, and I thanks all participants, those who have come. And every time we are working out. And as you are aware that today we started 3 years back on the same day when the lockdown has started, our first webinar. And today is the 125th webinar after 3 years. And the 3 years and 125 webinars without missing any Friday, we are continuously doing this CSR activities from our side. So friends, it is my promise, it is a promise of corporate professional that this journey of knowledge sharing will continue. And the same way, we will request our friends, our well-wishers, those who have a knowledge, they will come on this forum and share their knowledge to every participant. We have seen that people are coming in large number. We have seen that 92,000 people have registered till now. It's a unique number for our various webinars. And they are coming with their choice. There's somebody like security law, somebody like company law, somebody like insolvency law. Accordingly, they are coming. But we are doing program without focusing on the number. We are organizing program on different basis. So our next program, which you are seeing, this journey will continue. And the next program, as you are aware, that on first Friday of every month, we are doing updation. Whatever has come in last month to this month, whatever new thing has come in company law, security law, and the FEMA law, and the insolvency. These are the 4 laws we are focusing because this is the most important corporate law part. So whatever new is coming, we are discussing. So in case you have missed out any law, any updation, any point, we discuss here threadbare that what is this present law, what is the new law, what are the difference, and how it will impact. So just come on Friday at 4 to 6. You will get all the updation, all the knowledge, and all the expert advice from various professionals. So thank you very much. Thanks everybody for continuing and parting with our journey of this knowledge sharing. And we will meet you again on 5th April, 4 p.m. to discuss the new topic, that is updation on corporate laws. Thank you very much.